Hello, this is Maryland Estate Planning Attorney Stephen J. Reichert talking about selecting a trustee. Selecting a trustee is one of the most important decisions you'll make when forming your trust. To begin, let's discuss briefly the two kinds of trusts available to you. First, we have the testamentary trust, which is a trust that is created within a will. The other is a non-testamentary trust, such as a revocable or irrevocable trust, which is a document created outside of a will. When creating a testamentary trust, the trustee you select begins to serve either during or after the administration of your probate estate. The trustee is responsible for investing and reinvesting the trust assets, dispersing assets to the beneficiaries named in the trust, and ultimately terminating the trust by making final asset transfers to all beneficiaries. With a non-testamentary trust, the trustee begins to serve when the assets are transferred into the trust. The person establishing the trust, known as the settlor or grantor, often names him or herself to serve as the initial trustee. The settlor should name successor trustees who will assume trustee responsibilities when the settlor is incapable or unwilling to continue as the trustee. The trustee of a revocable trust has the same fiduciary duties as the trustee serving under a testamentary trust. Now, in selecting the trustee, it's important to realize the difference between the role a trustee serves and the role that a personal representative who's selected within your will serves. While a personal representative will serve for a very limited amount of time, just long enough to see your estate through probate, typically a few months to at most a couple of years, a trustee may serve for many years in their capacity. And depending on the size of the estate and the complexity of the investments in property, you may need to assign a trustee who has the capacity to handle the increasing demands of that position. That said, a trustee is permitted, and quite frankly, I often encourage them, to seek professional assistance on matters that are beyond their individual capacity. For example, a family member could serve and they could solicit advice from financial experts, accountants, and attorneys as needed. Another option is to appoint a corporation to serve as your trustee. However, this will come at an expense to the trust. Above all else, and this is the most important thing when selecting a trustee, your trustee must be a resourceful person who has a high degree of integrity. If you're considering appointing a spouse or beneficiary as a trustee, there are potential pitfalls that you should discuss with an experienced estate planning attorney. It may be necessary to appoint an independent co-trustee and limit the beneficiary's rights by clearly defined standards. For a free, confidential conversation to discuss selecting a trustee, the benefits of having a trust, or creating your own estate plan, contact me, Maryland Estate Planning Attorney Stephen J. Reichert.